Good morning. Melanie Yaw here. Welcome to the Airden Burles End-of-Life Decision-Making webinar. I am going to serve as the host this morning. I am a lawyer within the Estates and Trust group here at Airden Burles, and as part of my practice, I deal with end-of-life decision-making in terms of drafting of powers of attorney and expression of wishes and values. I'm going to touch upon more of that later. But first I want to introduce my co-presenters this morning. Sitting across from me is Judith Wall. Judith is a lawyer practicing as a legal consultant and speaker. She has her own practice now, Wall Elder Law. Prior to that, she spent over 30 years as executive director and senior lawyer at the Advocacy Center for the Elderly, which we in the biz call ACE. She has been a very active advocate for the rights of older adults and has a particular interest in end-of-life decision-making and will have more to say on many topics as we progress through this morning's webinar. And then to my right, I have Dr. Jeff Myers, who is a palliative medicine physician and medical director at Bridgepoint Palliative Care Unit within the Sinai Health System. He holds the W. Gifford Jones Professorship in Palliative Care at U of T, where he's an associate professor and director of the Division of Palliative Care within the Faculty of Medicine. I can tell you that both Judith and Jeff, I'm going to call you Jeff this morning, I hope that's okay, are regular speakers on the very subject that we are to discuss today, which is end-of-life decision-making. In the 45 minutes that we plan to speak, we're going to cover a host of topics. What does end-of-life decision-making encompass? How are healthcare decisions made at the end of life? And why is it important to address substitute decision-making while you are capable? There we go. How personal care decisions are made by substitute decision-makers and some considerations in appointing an attorney for personal care and in communicating your wishes, values, and beliefs around health care. We're going to try to dispel the myth of the living will and advanced care directives. We're going to touch upon how disputes related to medical care, in particular medical care at the end of the life, are resolved. And we're going to wrap up with tips for maximizing empowerment at the end of life. We do plan to leave, I hope, 10 to 15 minutes at the end of this morning's webinar to provide you an opportunity to pose questions and for us to give you our best answers. So with that by way of introduction, I'm going to now hand it over to Jeff, who's going to elaborate upon what the concept of end-of-life decision-making involves.
Thanks so much, Melanie, and good morning, everyone. Thank you for the invitation today. You know, this is such an important topic, and very, very grateful for the opportunity to speak with you. And I wanted to start with, on this slide, is really talk about what currently happens with respect to end-of-life decision-making. So in the last couple of weeks of a person's life, the vast majority of decisions are not made by the person. So I think that's a really important point to start off with, is that if you think about it, when a person is near the end of their life, they're not likely to be alert, not likely to be communicative, not likely to be able to understand information, and so really it is incumbent upon others to make decisions for that person. Currently, the impact of decision-making on substitute decision-makers is trauma. We're actually having to use trauma scales to measure the impact.
What's a trauma scale? So
as opposed to anxiety or depression, when we're measuring the levels of anxiety or depression, we actually have to measure the levels of trauma. So how we're traumatizing substitute decision makers by the decisions they're having to make.
All right.
So the ways that we're asking people to make decisions, and then the kinds of decisions that people are needing to make, are causing them to be traumatized. So really, this conversation this morning is about how do we prevent that? How can we try and improve the experience in those last few weeks for a person and their family member and the healthcare team as well. This slide, I think, I've just meant to I kind of touched on each of these points already. I think, the bottom line is that this conversation in general this morning and overall around end-of-life decision-making is really to empower patients, people, and reduce the stress that themselves and their loved ones experience at the end of life. And really it all comes down to effective communication.
Great. We'll come back to that later in the webinar, but in the next slide, I just wanted to, I think, hammer home the extent to which Canadians don't plan for decisions around their end of life. And just some statistics on this slide from a 2004 poll conducted by the Canadian Hospice and Palliative Care Association. 8 out of 10 Canadians would readily agree that people should start planning for their end of life while they're capable, yet 70% of Canadians surveyed in 2004 did not have a document outlining their wishes at end of life. 47% of Canadians, to my surprise, had not designated a substitute decision maker to make healthcare decisions if they were incapable of doing so. And fewer than 44% of Canadians have discussed end-of-life care with a family member. Only 9% have had a discussion regarding end-of-life care with their physicians. And on that last statistic, I want to come back to something you and I were talking about, Jeff, before we started the webinar this morning, which is the, I guess, the lack of dialogue that many patients have with their treating physicians, even at the end of life, around their prognosis, the likely course of their treatment. Can you elaborate a bit upon that?
Absolutely, yeah, and I would actually back up even further and say their diagnosis. So I think that of all the illnesses that people are dying from, congestive heart failure, lung failure, kidney failure, there is a very poor understanding in general as to what it means to have one of these illnesses. The incurable and progressive nature of these illnesses tends not to be fully appreciated by people, and so it's a surprise when they become ill, or it's a surprise if they don't improve. And that's really where I think we're falling short in ensuring that decisions are well informed, because people actually don't fully appreciate their diagnosis, let alone the prognosis. Right. One thing on this slide that I think is important to point out is I'm actually a little bit reassured to an extent about the bottom two bullet points, 44% of Canadians having discussed with a family member versus a physician. It's actually far, far, far more important that those discussions occur with family members than they do with a physician. So I just wanted to, although that 9% is worrisome, I'm glad that the family members is much higher.
So these statistics are from 2004. Do you think this has changed at all in the 14 years since?
Yeah,
Judith?
No, my experience that people don't want to face the end of life. Now, some things, what's encouraging to me is the fact that our law in Ontario does provide that you have an automatic substitute. So at least, even if you haven't chosen somebody, there is somebody there. But I still think it's really important that people know who that automatic person would be, or as well as, better yet, do a power of attorney to appoint the person you want. But I think people are very reluctant to talk about it. And I agree with Jeff. I think there's a real problem in our system is that people are not getting the information about their illnesses, and so what we call illness understanding. So they can't even participate fully in doing informed consent. And I think that's part of the traumatizing, because they don't even know what they're supposed to make decisions about. And I think people have to try to be proactive in asking questions, as well as health practitioners doing a better job of explaining the illness.
Right. So just to pick up on your point about informed consent, I'm going to pass it back to Jeff, who's going to elaborate upon how decisions are made from the informed consent perspective.
Absolutely. So I've learned a ton from Ms. Judith Wall about the legal framework in Ontario, and I would say that what I've learned is that we actually have it right in Ontario. We have the right legislative framework in place that could really enable and facilitate proper conversations and proper person-centered care. And I can't say that for many jurisdictions from around the world. So I think that we've actually got the perfect framework in Ontario to do this well, and part of this comes to this first bullet point, which is for every healthcare decision, it requires consent, and consent comes from a person. has to come from a person. Only a person can consent. A piece of paper can't consent. That phrase I learned from Judith Wall many, many times. A piece of paper cannot give you consent. And so if we think about the consent needing to come from a person who has mental capacity to give consent, that might be the patient. And if the patient lacks mental capacity or is incapable of making that decision, then it would be their substitute decision maker, who also needs to be capable. So it gets a bit complicated, I would say, around who and how decisions are made. But I think the most important piece is that consent is given by a person. The person needs to be capable. If the patient is not capable, then it falls to the hands of the substitute decision makers. Important point, capacity is not a general diagnosis. It is very issue or decision specific. So a person can have the capacity to make a decision about being referred to a specialist, but may not have the capacity to make a decision about surgery, for example. So at the same point in time, a person could have be incapable for one kind of decision, but capable for other kinds of decisions. So that's an important point.
Must be very challenging.
So, and this comes down to how do we actually assess a person, what's required to determine a person as being capable. A person needs to be able to understand the information that they're being given about the treatment, about the decisions, about the absence of a treatment decision, or personal assistance, I should say. On the bullet point here, second from the bottom, be able to understand the information that's relevant to making a decision about treatment, admission, or personal assistance. And I think I just want to underscore that, because it's not just treatments, it's also about admissions to different kinds of facilities and different kinds of care settings, and then also personal assistance, the care that's provided by personal support workers from long-term care facilities, for example. These are all these are all examples of consent decisions that a person would need to make, and capacity needing to be present in order for a person to be able to make it. The second piece of the puzzle for capacity is that a person can appreciate the reasonably foreseeable consequences of a decision or a lack of a decision. So I think you've summarized it really nicely, Melanie, in the last point, is that it's about more than just knowledge and understanding. It's actually insight. It's understanding and being able to appreciate and apply the information that may be new. As a clinician, so when there are hundreds of capacity decisions or capacity assessments that I make every day that I don't even realize I'm doing it. So when I'm speaking with the person, I'm subconsciously determining whether or not it's appropriate for me to be having this conversation with this person if it's leading to a decision. So capacity really is presumed unless something triggers me to say, hey, this person may not have capacity. Then we need to do a little bit of a deeper dive just to really truly understand how the person is appreciating the information. I think it's really important that just because a person is leaning in a direction or actually making a decision that we may disagree with, it doesn't make them incapable. So family members are often unhappy about some of the decisions that a person would make, and that I've seen actually a number of circumstances where capacity is inappropriately called into question because there's some disagreement and conflict within the family.
Thanks, Jeff. Judith, you touched upon, the fact that our Ontario legislative framework provides for substitute decision makers. Perhaps on this next slide, then, you can just run through the relevant provisions of the Healthcare Consent Act.
So as Jeff was saying, if a patient is found incapable by the treating practitioner, then they do have to turn to the patient's substitute decision maker. So then who is that substitute decision maker? So within the Healthcare Consent Act, there is a hierarchy. It's a list of who would be the decision maker. And it's whoever in your life is highest on this list. But I'll explain this list in a slightly different way. So first of all, everybody in the province has an automatic substitute decision maker, even if they've never done any planning, even if nobody's ever gone to court or to a tribunal to get an order naming somebody as the decision maker. So you need to know who would be your automatic decision makers, because you may not want them. So who would be your automatic decision makers? It's all family. So it first starts out with your spouse or partner. Now, spouse is a very broad definition. It's same-sex, opposite sex, somebody you've lived with for at least a year, somebody you've had a child with. Partner was actually the original definition put into the legislation to capture same-sex spouses, because in 1995, same-sex spouses weren't recognized. So a partner is somebody you live with at least a year, but it's a relationship of close personal importance. So that still is relevant, because you could have people, as an example, I had 2 clients who were 2 elderly women. They were not partners, same-sex partners. They were just old friends, but they had lived in the same household for 32 years. They knew each other better than anybody else. They really were a family unit. So we argue that they were partners for the purposes of this legislation, and that was upheld.
Interesting.
So after spouse or partner, it's your parents or children. So you could have a 95-year-old parent and 3 kids, and they all equally rank. So it's not that your children get priority over your parent. And if you've got multiple children, they all equally rank. So it's not based on sex, it's not based on age. Then you get into your siblings, brothers and sisters, any other relative by blood marriage or adoption. So those are the automatics. Now, somebody can do something to create a substitute decision maker. So the most common thing is you yourself, while capable, can prepare a power of attorney for personal care where you name 1 or more people to act as your substitute. So these could be of your choice. So it's very important. If you don't want your substitute, you need to do a power of attorney for personal care. Also, somebody could go to court to be appointed as your guardian, or somebody could go to the Consent and Capacity Board to be named as your representative. That's just the name of the decision maker. And then if you have no one on this list that meets the requirements to be a substitute, and I'll explain that in a moment, then it is public office, the public guardian trustee, who would step in place of all these other people and make decisions for you. But as I mentioned, the requirements, just because the person's highest on this list, they still have to meet these requirements. So the substitute, to be a substitute, must be at least 16. They must themselves be capable in making this decision. They can't be prohibited by a court order or a separation agreement. And most importantly, they have to be available and willing to act. So just because your daughter is the highest ranking, she may not want to act as your substitute, and she could just say, I'm not doing it. Mm-hmm. Even if you appoint an attorney, they could say the same thing. So even if you're appointing an attorney, you need to make sure that they're willing to take on this task. And if there's a dispute between people, you can get whoever's highest ranking plays the role. Other people can challenge that in some ways, but they'd have to go to court to remove them, or go to a tribunal to get the order to be a representative.
And is there, just on that point, you mentioned court, tribunal, is the route, the Ontario Superior Court, or is it the Healthcare Consent Board?
Well, if you're going to go for guardianship, you're going to go to the Superior Court, or if you don't have a power of attorney and the dispute is amongst your family members, they can go to the Consent and Capacity Board, much faster process, and they can outrank the person. The other thing I should mention with disputes, if you have equal ranking substitutes, so say you've got 3 kids, if they can't agree on a decision and they all insist on being your decision maker, it actually goes to the public guardian trustee, the public office, not to the next highest ranking. So that's why it's very important to think about, if you're picking somebody, pick somebody you can trust. If you're doing the power of attorney, if you're doing multiples in a power of attorney, make sure they can get along, because if they can't agree, it's going to go to the public office.
Right. And that just to bring home that point, that is a statutory provision. It's in the Healthcare Consent
Yes,
Act.
it is. It's in the Healthcare Consent Act.
Right. So then you've mentioned, you've touched upon a few times, rather, Judith, having a power of attorney for personal care, and I'm going to get into that in a second. But maybe, if you wouldn't mind, you can just talk about, elaborate upon the cost of not appointing a substitute decision maker. I see it in my practice as a litigator that where there isn't a substitute decision maker that is available and the like, and there is someone, perhaps a neighbor or a close friend, who doesn't fall within the hierarchy, who might be prepared to act, that there's a need to apply to the Ontario Superior Court for a guardianship of the patient or incapable person. And I can tell you from my own experience that the cost of bringing such an application is time-consuming, there's a delay, and there's also a pretty high expense. Do you have any other thoughts on that point?
Well, the other thing, people have to remember that that hierarchy list is just for health care. So there are other personal care decisions that people have if they should become incapable that need to be made. So, for example, shelter decisions, that's a personal care decision. And one of the situations arises where if the person becomes incapable to make a shelter decision, but they don't need as high a level of care as a long-term care home, so the alternative would be a retirement home that would provide some supports. They actually, the only decision makers who could actually sign those agreements for the retirement home are an attorney named in a power of attorney for personal care or a court-ordered guardian. So if you don't have the power of attorney, that is going to require somebody going to court in order to be able to sign the agreements for that kind of tenancy.
Right.
So it needs to understand there's more than the health decisions. But in health decision-making, people should feel confident they have an automatic one. The other thing is if you've got if you don't talk with somebody and actively turn your mind to who would be your substitute, you may have somebody making decisions for you that you would not want, and the kinds of decisions they would make may not be what you would have preferred. They're supposed to step into your shoes, but there's actually very little oversight of that person in how they decide. And so unless somebody goes off to court or to a tribunal to try to trump them, that's a very stressful process and expensive process.
Which then leads me into, I'm just in the next few slides going to touch upon the document we know as a power of attorney for personal care. In Ontario, as many of you would know, there are actually two distinct documents, a power of attorney for personal care and a power of attorney for property. In the case of the first document, you are appointing one or more people to make decisions for you relating to your personal care if you're incapable of making them for yourself. Personal care includes not only health care decisions, but as Judith touched upon, decisions relating to shelter, hygiene, diet, who has access to you, and the like. That is distinct from a power of attorney for property, which appoints one or more people to make decisions regarding the management of your property and financial affairs. I'm going to just focus, for the purposes of this morning, on the first document, powers of attorney for personal care, and the management of personal care is governed by the provisions of the Substitute Decisions Act, which dovetails, I would suggest, with the provisions of the Healthcare Consent Act, at least as it relates to medical care. An attorney for personal care must be at least 16 years of age. Importantly, they cannot be providing health care to the grantor for compensation or providing social, residential training or support services unless they are a spouse, partner, or relative. So this would, preclude a personal support worker, for example, from serving as an attorney for personal care. The power of attorney for property, or personal care rather, is executed by the grantor while they are capable. And it's just, I could spend a great deal of time talking about this issue, but just some important considerations when you are deciding who to appoint. One of the most important, I would suggest, is physical proximity. So they ought to be in and about the community that you live in. They should as well be willing to act. That's implicit in all of this. And I will tell you, in my practice, I often see a client who suggests that their child who lives in California is more than capable of serving of their attorney for personal care, and I will tell you from my perspective, I try to discourage that because it's not practical. The key thing, too, to think about, you want an attorney for personal care who is going to be able to make decisions under pressure and in accordance with the wishes that you've expressed. And a really important consideration is how many people to appoint as your attorney for personal care. I will tell you, appointing one who's who lives in the community and who's willing to act is a good idea. Sometimes clients have multiple children and they want to appoint all of their children. I had one case where the grantor appointed 5 children who were all expected to act jointly. One lived in Hong Kong, one lived in Nigeria, 2 lived in Canada, 1 lived in California. I mean, it was impossible. So there needed to be an application brought for guardianship, appointing a trust company, and one of the children as in respect of property and one of the children in respect of personal care. Where you appoint more than one, you want to give serious consideration to whether or not they have to act jointly or whether they can act severally, making decisions on their own, which at first glance might seem like a good solution to a tough problem, but I can tell you from and Jeff, I'm interested in hearing how it plays out in the clinical setting, but I've encountered situations where there were 2 or 3 attorneys for personal care appointed who were able to act severally, independently, and then they each gave conflicting instructions to the healthcare team. You're nodding, so
Yeah,
I'm assuming
absolutely.
this is something you see.
Absolutely.
Yeah. And that is a challenge. Always a good idea to appoint alternates because, as Judith said, an attorney for personal care doesn't have to act if they don't want to. More importantly, they may have passed away, they may themselves be incapable, or they may be unavailable. And when you appoint more than one, you should think about how decisions are to be made, whether they have to act jointly or whether the majority can decide. All things that you need to think about. And the last point on this slide is that, it's so important to be honest with yourself about how decision-making is likely to play out. I have had clients who've said, I recognize my children don't get along, but it's really important to me that they come together in a time of crisis and act together. But if that's not how it's going to play out, it makes no sense to appoint them. And Jeff, you're
if
nodding.
I could just say, yeah,
absolutely.
If children did not agree
during their
all of
lifetime on simple things,
it's not going to all of a sudden come together in there
And
at
right.
the end of a person's life.
Even if they've always agreed in all their lifetime, when you get to this high-stress situations, it's fascinating to see that people go off in all different directions. Because then people go, well, Mom liked you better. I've got to now make up for that by doing something. I'm going to keep her alive. And when everybody thinks that they shouldn't be making those kinds of decisions. So it's something to really seriously think about if you're to not assume that your kids are going to get along.
Right. So then I'm going to touch now upon what the Substitute Decisions Act contemplates in terms of how a personal care attorney would make decisions. The legislation provides that the attorney for personal care must act in accordance with the patient's previously expressed wishes, whether they're written or in oral. And on that point, I want to point out that it's the last wishes that were expressed by the grantor or the patient that are to be honored, not wishes that were given historically if they've been superseded. And if there are no previously expressed wishes, the attorney for personal care has to act in accordance with the patient's best interests. And I'm going to pass it over to Judith just to talk about how a patient's best interests are determined.
So best interest actually is a defined term in the Healthcare Consent Act. And I actually really like the definition because I think it helps people think through what does that really mean. So best interest, if the substitute doesn't know of a wish that's applicable to the decision, then they need to think about the values and beliefs that that person had while they were still capable. So what does that mean? How would that person have decided if they were still able to make decisions for themselves? So it's understanding of what's important to them. What do they think is quality of life? Even if a person is incapable, the substitute should be interacting with the patient because they still can communicate something. They're still there, although it may not be capable. Those wishes expressed while incapable are not determinative. They don't have to be followed. But they may be indications of where that person is. I've seen this frequently with people with Alzheimer's. They are communicating something. We just don't know what exactly they're communicating. But to think about, is this applicable? So then they also have to look at whether the decision is going to improve the quality of life of the person, if it will prevent it from their quality of life from deteriorating. So you're looking at a risk-benefit analysis, and it's really does the treatment benefit outweigh the risks that are involved. So it's really thinking through who this person is, how they decided for themselves while they were still capable, and the substitute's trying to step into their shoes and think from their perspective. So not from the perspective of the substitute, but from that perspective of that person. So what would be best for them if they were still able to express what they would want for themselves.
Okay. And we've touched upon this briefly, or you just did, but perhaps you can just expand upon, Judith, the extent to which, if at all, an attorney for personal care has to consult either with the patient or with family members.
This is a very important point. The attorney really is supposed to consult with that person, even though they're incapable, because they still can often communicate very important information to that person as to how they're reacting to the treatments, what's going on in their lives, their choices. The person's still there. But the point about the consulting with the patient's supportive family members, they should be including the rest of the family, at least not necessarily to decide for the person, because a substitute is playing that role, but the family is still a contact to them. So I had many cases when I was at the Advocacy Center for the Elderly where the attorney would block all the family from visiting the elderly person in the long-term care home. In my opinion, I don't think the substitute has that authority because of this duty. They can't block them unless it's a situation of risk. If the other family members or friends are going to potentially cause harm to the person, then they may have an argument to restrict their visiting rights. But otherwise, they should be encouraging that, because that person is still a person. That was part of their life. So that's a very important duty that's often not totally understood by the substitutes.
Absolutely. So now one of the key things I wanted to do this morning was dispel, to the extent the three of us could, this myth of the living will and the advance care directive. I know I've spoken to you at length about this, Judith. Perhaps, would you mind just touching upon that?
Sure. So the terms living will, advance directive actually come from other jurisdictions. I think they're primarily American-styled forms created in the states in various different pieces of legislation, state legislation. This terminology is not in our law. In our law, it talks about wishes, and I think that's good because the living will and advance directive concept makes it sound like you can make decisions for yourself in advance. You can decide who would be your future substitute, but you can't really decide about your care in the future fully because, as Jeff had pointed out, all care requires an informed decision, an informed consent.
Decisions are decision.
Decisions need context. They need information. So you need the information about the patient's present health condition and the possible treatment options or living options then to make a decision. So calling these documents advance directives living wills make it sound like they're final, and they're not. It has to be understood the substitute is the decision maker when the patient becomes incapable. They have to interpret the wishes and apply them. So you can't totally block them off. Yes, the substitute has to follow the wishes the best they can, but they have to apply them. And it's that application that's the big thing. The other thing is I did a research study for the Law Commission where we did ask physicians in particular, what if something's called a directive, what do you do with it? And they said, we follow it. And in fact, these wishes, however written up or communicated orally or communicated by other means, are directions to the substitute, not to the health practitioners. So by calling these things directives, and then it makes it sound that the health practitioners have to follow it, and that's not the case. That's not the law. And it's better. We really need to talk to a person. They need to talk to a person. The patient, if capable, the substitute not. I've also seen these, particularly the advanced directive forms, used as though they were consents or advanced consents. And that's also inappropriate. That's not what we would want. You want decisions in the context of your condition at any particular point in time.
To what extent, Jeff, do you see directives, written directives?
Very frequently, I would say. And maybe an example might help just to try and clarify. some of the myths around living wills and advance directives. So often we'll hear people say no machines, or I don't want to be hooked up to have tubes and be hooked up to machines when I die. That is actually incredibly unhelpful information, because let me tell you what happens when an 80-year-old man who's got some lung failure gets pneumonia. He gets a bit confused and is brought into emergency. His wife is then asked to give consent for all kinds of treatments and antibiotics. He worsens in the first day, and the critical care team comes and says, "We'd like to bring him to the critical care unit. Our hope is this is only going to be for a day or two of the machines and the tubes, and our hope is he's going to get back up to baseline, who he was when he came or
Right.
before he got ill." The likelihood that will happen is it's probabilistic. We don't know, if he actually
Right.
he will return back to baseline. But in that moment, it would be very difficult for any spouse to say no when a clinician is saying, even though the patient may have said no tubes and no machines. So it's an example of how living wills and advance directives are not effective. There's no evidence that they actually impact end-of-life care or end-of-life decision-making.
Nor ought they to, right?
I think so.
Right.
I think so.
Right.
And it actually is a nice segue into the next
Right.
slide, which is how can we prepare spouses? How can we prepare our family members to try and prevent that trauma that could potentially happen if they're needing to make decisions for us on our behalf? And that's really what advanced care planning is. So I want folks to think about advanced care planning as two things. The first is to confirm your substitute decision maker. So is this the person, the automatic, is this who I want? And then the second step or phase of it is to prepare that person with the information that would best guide decision-making or best guide consent processes. That's how consent and advanced care planning link, is that advanced care planning is really about preparing substitute decision-makers. And it's actually not I disagree with the Ontario Medical
Okay.
Association.
Interesting.
Here I say it, stand firm on that, because it's actually not about what a person would want. It's not about the sorts of treatments, and it's for the very same reasons, like the example that I gave you around machines and no tubes. If you make it about treatments, then you miss the boat. There are two components of any decision. There's the information about the person and information about the treatment. Those things, a substitute decision maker, when they're making a decision, they need to consider who the person is and then information about the treatment. We lose who the person is. We forget about that piece all the time. We spend so much time focusing on the treatment and on the evidence, and we forget who this person is, what they value, what's important to them. That's the information that's going to be helpful to a substitute decision maker, is who this person is. It's actually why the gentleman wouldn't want machines or tubes, not the fact that he wouldn't want the machines or tubes. It's why he wouldn't want them in the first place. I think I touched on a few of these, but just to reiterate. So when you think of it in that way, if advanced care planning is intended to prepare substitute decision makers, then only a person could advance care plan. A substitute decision maker couldn't advance care plan for a person or for a patient. It's really important that the person has capacity when they are expressing these wishes. Now, I'm not a huge fan of the phrase wishes, because I think it is so interpretable. My preference would be values or beliefs, things that are meaningful, things that are important to the person, and try and stay away from preferences, the word preferences as well. That's just my bias, I would say, because I think we get into a slippery slope towards treatments if we use words like preferences. So I think that takes care of the next few bullets, because really what is the most important outcome is that a substitute decision maker has a better understanding of who this person is, what's important to them, and what matters.
Right. And before we leave this slide,
Yeah.
we talked about medically assisted dying before we started the webinar this morning. And I have to think, Jeff, that the topic has to be part of most of your advanced care planning discussions that are going on with patients these days. Is that true?
So it's a really good question. I think what's important for people to know is that to receive assisted dying, to actually have your death assisted, you have to be able to give consent
Right.
the moment that just before the medications are injected. So it really, when you think about it, it can't be a part of an advanced care planning conversation, because it's not about preparing the substitute decision makers for a decision. that person is the only person that could make that decision.
Right.
So medical assistance in dying really shouldn't technically be part of advanced care planning conversations. I think it's, again, the why. Why is a person wanting to explore and talk about these things? That's the information that would be helpful.
But one of the points you made
Sure.
to me this morning was that that the topic is discussed far more frequently now as a result of legislative amendments than ever before.
Absolutely. Sorry. I would say end of life care in general in society there's a much greater ease and comfort, and in large part it's because medical assistance in dying has really catapulted that conversation and normalized it and socialized it much greater. So I'm in that way absolutely grateful. But it complicates things from a decision making capacity and legal perspective for sure.
Right. So just to wrap up the advanced care planning topic, perhaps, Jeff, you can run through these points, which I pulled from one of your webinars that you gave earlier.
This is what makes palliative care and this topic so relevant, because if we do this well, then it's win-win-win in terms of the
reducing trauma, as you
absolutely,
mentioned.
Yeah, and I think really important. This is what gets the system leaders' attention, is that we reduce hospitalizations, we reduce admissions, and then overall costs, which, as we think about our aging population and we think about boomers and their healthcare needs moving forward, those are important considerations.
Okay, so we have about 5 minutes before we get to questions, maybe 5 or 10. Perhaps, Judith, this is another topic that could form the basis of a webinar, in my view, but maybe you can just touch upon how disputes between and among patients and healthcare providers, substitute decision makers and patients, and the healthcare team and substitute decision makers and the patient's family and friends are resolved in the roles played by the Superior Court and the Ontario Consent and Capacity Board.
Overall, a lot of these matters, even if there's disputes, don't go into the court system or to the Consent and Capacity Board, but they can. Because people negotiate, they work it out between themselves. Many of the times that I've been involved at that preliminary stage, it was because of misunderstandings that there were disputes. People didn't understand the illness, they didn't understand the treatment options. So among substitutes, if there are multiple substitutes and they have to decide together, and they all want to decide, none of them want to drop out, then they do need to work together and have that illness understanding, have an understanding about the treatment options, and pursue that. If they can't resolve the dispute between themselves, it actually doesn't go into the court or tribunal system. It goes to the public guardian trustee. So it's an automatic move. The health practitioners don't have to wait until there's a proceeding. So that's what substitutes need to understand. If they don't agree, it can go to the PGT. If you've got the dispute between the substitute and patient's family and friends, the substitute's decision is going to take precedent because they are the substitute. However, that's because there's a potential of this kind of dispute. I often say to my clients, although you've picked somebody as your substitute, you're communicating with them, you may want to communicate to other family members, particularly over things that have become more contentious. And end-of-life care is one of those big issues. There's a lot of emotion involved with it. So can you anticipate who else in your family may have difficulties with decision? So you communicate to them what you would want, so the substitute is better supported. They've got the supports. They can remind the other family and friends that you had certain wishes about your care. But if you can't resolve those disputes, family could apply to the Superior Court to become a guardian, which will override the substitute. If the substitute is not an attorney, then the family members could go to the Consent Capacity Board. So say it's your spouse as a decision maker,
right,
but your kids disagree, they can go to the Consent Capacity Board to be named the representative. And if you've got the disputes between the substitute decision makers and the patient's health care team, again, the first step is negotiation. Are people all on the same plane? Do they understand what's going on? Ask questions. But the substitutes have to understand the health practitioners actually can go to the Consent and Capacity Board if they believe the substitute is not following the wishes expressed by the patient when capable or not acting in their best interest. there is what's called a Form G application to the Consent Capacity Board, where the health practitioners could ask the board to review the decisions being made by the substitute. At the board, they look at is the substitute acting according to wishes and best interests, and if the board agrees with the health practitioner, disagrees with the substitute, they can order the substitute to make a particular kind of decision, and if they fail to do that, the substitute could be removed from being the substitute. So you can see a lot of these are last resorts. But people need to do a lot of that conversation and talking. That's why I'm a big supporter of people doing that advanced care planning, to have discussions, but also talking with other family and friends, so that basically those people will provide supports to the substitute.
Right. Everyone's on the same page.
Correct.
Regarding decision making. So we'll wrap up the webinar proper with some tips regarding maximizing the empowerment and the reducing trauma at the end of life. I think it's important to recognize that each of us will go through the end of our life. Oh, yes, Jeff reminded me I need to switch the slide. Each of us will experience our own death, and advanced planning, as Judith said, is one of the keys to reducing trauma and maximizing empowerment. One of the key ways to do that is to have a valid power of attorney for personal care in place. And because the Health Care Consent Act, as Judith pointed out, only covers certain areas, and there are broader areas of personal care that need to be dealt with if someone loses capacity. One thing I'll just say as the drafting lawyer in the group, you should consider executing multiple powers of attorney if you're spending extended periods of time outside of Ontario. So I have clients, for example, who spend their winters in Florida or in Arizona or in the Caribbean or in Europe, and I always encourage them to retain counsel in those jurisdictions and make sure they have valid powers of attorney for personal care, because the decision-making process is very different could be very different in other jurisdictions. It's important, to come back to what Jeff said, to engage in advanced care planning and to provide meaningful guidance to your substitute decision maker, whoever that might be. Jeff, Judith, do you have any other additional tips?
I would say the thing to think about is not about specific treatments you would want or not want in the future. I think that's one of the big failures. People think that they can control that. That's extremely difficult to control. You don't know what's going to happen to you. Medical services change. What was possible now wasn't possible a year ago. So all of these things it's a moving target. What you really want to do is try to communicate with your substitute and your family what's important to you in your life, what makes quality of life. That's a very vague term. It could be anything. But how do you make that substitute confident that they're making the best decisions for you in the way that you might have made for yourself if you were still capable? How do you support them so that they feel comfortable playing that role?
I would say if you have a picture in mind of what you would want or what you would not want, so the outcomes of treatment, I would create that picture for your SDMs, for your family, share that picture, and tell them why that is your picture. So if you have a sense of what you would want, what it looks like, what that image is, why is it why is it that you would want that? Why is it that you would not want that? Right.
And presumably you should communicate that to your healthcare team as well.
Ideally,
right.
But again, it's not going to be the care team that's caring for
right.
you
that's
at
a good
the end
point.
of the life, right? So it really is about preparing the family and the SDMs.
Okay, great. So we'll move on now. We have a number of questions that have been sent both this morning and in advance, and I'm going to serve as the questioner. If that's okay. A couple of these, I think, are in your bailiwick, Jeff, so I'm going to pass those along to you. One of the questions that was asked was, what actually transpires in an emergency situation where a client, or patient rather, comes in, and, to what extent are heroic measures taken If they've got an end-of-life document that specifies certain courses of care, how does the healthcare
Yeah.
team react?
So this is a great question, because what we neglected to say is that consent comes from a person except in an emergency situation. And Judith can elaborate maybe a little bit on the legalities of it. But when there is an emergency, an urgent, a critical situation, then healthcare teams can use forms, can use guidance from many different contexts. If a decision needs to be made right in the moment, though, they'll tend to default to providing the treatment or providing the care,
Right.
Unless there's very, very clear evidence or reason to not. But I would say that that's the only situation where we wouldn't be seeking formal consent. Did you want to say anything about that, Judith? Just to...
Yeah, I think that's what you've said is fair, and I think people should try not to say things like, I don't want heroic measures. What does that mean? A heroic measure to you is very different than a heroic measure to me. I actually did a little study on that, very informal study, and when I asked a friend of mine who's a physician, I said, what's a heroic measure to you? That was a totally different answer than when I asked my mother. So you've got to really think about things could happen fast. You don't have a total control. In emergencies, they're going to treat in all likelihood. And they may not even know what your wishes are, like
Right.
what
That's
you
right.
had previously expressed. That's the most common thing, I think.
That's
is
right.
that
In an emergency
it's just-
room
it's just-
situation.
yeah, it's just not known. You end up in the emerge. Things happen very fast.
So just to come back to your point about expressing wishes and unhelpful expressions of wishes, I'm going to throw it back to the both of you. What would be a helpful expression of wishes? I mean, as a physician, what helps you understand what the patient or the incapable patient would want?
So the next, when I hear no heroic measures, or the opposite of that, which is do everything, I want everything done.
All heroic measures.
All heroic measures. The next question, that just opens up a series of questions for me. It's what is meant by heroic measures, first and foremost, but then what would it mean to not provide heroic measures? What does it mean if we were to provide heroic measures? And trying to get at the why. It's what's underlying, what's brought a person to have that opinion? Is it something they've seen on TV? Is it something they've experienced in a family?
Or a lawyer's told them.
Or lawyers told them. Something has brought that person to have that perspective, and it's more about understanding what brings a person to that and what's underlying that perspective. That's going to be helpful information.
Context. It's trying to help give a context to your substitute on what do you find is intolerable.
Right.
And so it's not enough to say, well, if I get Alzheimer's, I don't want to live. People will live for many years living with Alzheimer's. So that's not enough to say that, because the substitute is going to have to make decisions for you while you're living with that disorder. So it's what's the intolerability? It's like a feeding tube. What would you want a feeding tube if you could not communicate with others? And I'm trying to
Right.
give it an expanse, so you get a context.
Again, another example is I don't want to be a burden, right? So often
Right.
the number one thing that especially baby boomers want to avoid is being a burden. That's not helpful information.
Right.
It's what does burden look like, and getting to that level of specificity around what's tolerable and what's intolerable around having your care needs met.
This is clearly an issue I need to give some further thought to, because I draft powers of attorney for personal care where we're using language like no heroic measures, no feeding tubes and the like, and I've come to appreciate as a result of this morning that that is unhelpful to physicians who are actually treating.
Unhelpful to SDMs, I think, is the
Right.
sorry to hammer that point, because it is about trying to interpret that very specific contextual phrase that will have a completely different context that's being presented to the SDM.
And I think as lawyers, I think that was the training traditionally, and
Yeah,
I think
absolutely.
we've learned a lot over the years as we've more delved into this in greater depth, what happens at the bedside. That's what I've learned working so much with health practitioners and in the health system, and in the kind of practice I had at ACE, is that what I thought as a lawyer, what I had learned, it doesn't apply in the practical setting. So we have to shift our thinking to thinking, how would this be interpreted in the system at the bedside, or if before the Consent and Capacity Board? Because
Right.
what that board struggles with, what do these things mean? And so that's why I think a lot of this context really helps, and really diving deeper into that. And then it may not be able to draft something in particular that's going to work 100%.
Right.
To me, it's really coming down to who do you pick as your
Person.
substitute,
Right.
and how do they understand you, and will they do what you think that